In continuation of the previous lecture, now let me discuss with you what are the points included in the scheme of this act, or what I can say that the scheme of the Companies Act 1956 considered broadly with these four major headings. Those are incorporation of the company, forms and contents of memorandum, prospectus, issue of share capital or debenture. Incorporation of the company, which I will discuss with you in the further lecture or in the further slides. Prospectus had already discussed with you, forms and the contents already discussed, and then the issue of share capital. Management and administration, the another major broadly head that includes registered office, members, debenture holders, meetings, proceedings, accounts, audit, directors, and so on. In the similar way, it includes winding up of the Act and the miscellaneous provision. Winding up, which includes the modes of winding up the National Company Law Tribunal, or the voluntarily winding up. The fourth part, which is broadly classified, indicates miscellaneous. Miscellaneous, which includes foreign companies, winding up acts, and journal. Now let me tell you the company and its features along with the different clauses. If anyone asks you that what is the company and why there is a need to understand about the company, so I hope all of you are already aware of that what the company is. Basically, the company is governed as per the provision of the Company Act 1956. So that is the company, or if I talk about the company, then I can say you people, as you are already the students of the business administration, so it is an artificial perpetual succession person having the intangible or the invisible existence in the law. So company is an association of many people who contribute their money or the money worth to the common stock. That is said as company. Or if I say those who contribute money or their shares in the proportion of the capital, each member is entitled for the shares in the company, which is easily transferable also. So now, if these are the features of the company, the features or the characteristics of the company, that is, company is a incorporated association where two or more members join together, they form a company with the same purpose. In case the minimum of the 7 required in case of public company, in case of private 2 are required, and in case of banking it is 10 required, maximum is of 20. Company is an artificial person, artificial legal person with the capacity of law, with the sanction of law. So it is an artificial legal person, and where with certain rights and certain obligations the company is having. So it is like a natural person. Then company has a separate legal entity. It has a separate legal entity, means it becomes impersonalized. It has a separate entity. It is different from its members. So this is, and it has the capacity to sue. It can be sued and sued by the another members. So it can be sued by the members. It is the one which has the capacity to use. It has the capacity to use. It is a separate property. More so, it is not only a separate property, but it is framed with certain amount, with these certain shares. If I say the member in the company, they are not the agent or of the company, but they are the holders, the shareholders of the company. And here the liability of the members, the liability of members is to the extent of the value of the shares. So this is your company where the transferability of shares is there, and a company is a common seal also, where common seal is it can be held bound by only those documents which bear the signatures. So official signatures of company, that is in the part of the common seal. So I hope this much is clear, and though I haven't discussed it in depth, the reason is all of you already read all these points in very detail in your previous classes also, because all of you are from your background, same background, this management background. Now clauses are name clause, object clause, liability clause, your capital clause, association clause. So these are the various clauses of this Company Act, right? So I do not think that if you face any sort of problem in handling these points in your exam. If I talk about the this object clause, so object clauses which defines or confines the sphere of business, means that is the limit of the business where the activities to which business can be engaged, right? That is your object clause. Association clauses, where the company, there is an association or a subscription or a declaration of the association, so that is the association. Capital clauses, where which states the amount of the share capital with which companies are registered, or the mode of the division into the shares of the fixed value. So if there are equality, or if there is a equity in the preference share, then the division of the capital is shown in the different heads. Then if I talk about liability clause, liability clauses which states that liability of members is limited to the face value of shares. So in case the change in the liability, that is brought by passing the special resolution, then the liability can be changed. And if I talk about the name clause, the name clause itself indicates the word limited, private limited. So those are the part of the name clause. I hope this much is clear to you. Now let me tell you, let me share with you about your promoter. So roles and duties of the promoter. Who is actually the promoter? How the promoter is helpful in the incorporation, and what is the remuneration? So many things are there. Promoter is the one who is the point one, or who can say he is the one who is the idea creator. He is the one on the basis of whom the idea is generated, and on the basis of that the company is established, the business get established. He is the one who did the investigations, sort out the facilities available at the different places, find out the various resources, labor, men, money, material, machine, and then he is able to provide those facilities. He is the one who arranged the resources as well as the factors of the production, though the company obtains the capital by the issue of shares or debentures. He is the one who arranged the finance, satisfies after Prim's investigation. He is the one who implement these, the project. Then he is the one who involves in the preliminary contract. Preliminary contract is those made by the promoter before the incorporation of the company with different parties for the interest of the company. So he is personally liable for these contracts. So if these contracts are not approved by the company, he will be personally liable for these contracts, right? So he is the one also for appointing bankers, for appointing promoters, for appointing solicitors, right, as required to be approved by the company. So he is the one basically who performs lot of roles. I hope you are able to understand, and without whom it is not possible to establish that business, because he is the initiator, basically the beginner, because whose ideas are the base, and on the basis of that we start off, or one can think of to go ahead with the business, and to take that business in the another level, right? So he is that kind of person, means what I can say, the main one who involves in the formation of the company, right? So these are the points, or what we say, these are the roles and the duties which one must be aware of before involving in the these promotion stages. If I talk about the legal position of the promoter, so the promoter is neither the agent and nor the trustee. Keep this thing in your mind. He is not the agent, because he is not a principal also, okay, not a truster also. So the promoter of the company is accountable for all the money secretly obtained by him, maintain the relationship of the principal and the agent, right? His dealing is with the proposed company only, related to setup of the company. So this is your what I can say, the legal position of the promoter, and these are basically if I talk about, these are basically the steps also taken by the promoter, or what I can say, in the promotion stages, right? So I hope it gives you bit of the clarity about promoter, the roles of the promoter, duties of the promoter, the legal authenticity, or what I can say, the legal role of the promoter. Done? If any point which is left, or if you feel like to review that point, I will do it. No problem in that, right? So in the next slide, I will let you know about the another points.